Let's put this in proper perspective with a human rights activist and lawyer, Inibehe Effiong, as well as Todimu Ige, who is also a legal practitioner. It's a pleasure to have you both on the news tonight. All right, let's start with Inibehe. Thank you again for being here. What are the implications of the court's order to the Senate to lift the suspension on Senator Akpoti-Uduaghan? And will there be any impact on the Senate's disciplinary powers?
I think we have to await the certified true copy of the judgment of the court. I'm particularly interested in seeing the certified true copy of the judgment to see the extent to which the judge attended to the issues placed before the court. I'm concerned about the comment of the learned senior advocate who represented the Senate, a person who I know, Mr. Daudu SN, who is saying that the order for Natasha's recall was an obiter dictum. That is basically saying, by the way, and not a substantive decision of the court. We will need to see the judgment. However, the law has been clear. The courts have ruled in cases that were filed before now, including the case of Senator Ali Ndume, that Parliament has no power to place order of suspension on members to a point that basically amount to denying constituents the right to representation. Because if you say that this Senator Natasha Akpoti-Uduaghan should not be seen within the premises of the Senate for 6 months, it is ridiculous to expect that our constituents in Kogi State who came out to vote for her, who are constitutionally entitled to representation, will be denied the opportunity of having their voices heard in the Senate for 6 months. No matter what the infringement may be within the confines of the National Assembly. To say that you will now deny a member of Parliament that right to represent the person's constituency, for me, is rather unlawful and arbitrary. Now, regarding the aspect of the judgment of the court, that Natasha should offer an apology to the Senate, and that he should also tender and publish that apology on social media for the satirical apology that she posted on social media. Well, again, we have to await the certified true copy of the judgment. I'm also concerned that she's being asked to pay a fine of 5 million for contempt of court. I'm not sure if that is proportionate to the violation. Of course, contempt is a serious matter. But if you're asking her to pay a fine of 5 million naira, the court is also asking her to publish an apology. And now we're even hearing that even the order for a recall is not a substantive order. It's only an obiter, the lawyer has stated. I don't necessarily agree with the lawyer. I'm actually concerned whether justice has been whether this matter has been addressed the way many Nigerians have expected it. But again, we cannot begin to force the judgment without seeing the certified true copy of the judgment. So I'm a bit cautious at this point, but I must put on record that I entirely condemn any attempt to deny parliamentarians the right to represent themselves. If the issue is that she did not sit in the seat assigned to her, you cannot say you are suspending her on that basis. You cannot say that because somebody has decided to speak from a seat other than the one officially assigned to her, therefore you will deny that person the right to be in parliament for which she was elected into for 6 months. So the Senate president took that decision in a very blatant and illegal manner, and I believe that there is no basis to continue to deny Natasha her right to represent her constituents.
Anyway, you more than most know that sometimes our expectations run contrary to what the judges tend to present at the end of the day. While we await the true certified true copy from the court, as you've mentioned, do you think that if that is the case, the senator is going to do what has been ordered, apologize publicly and to the Senate, or you expect an appeal?
My anticipation is that, given the way the lawyer to the Senate spoke, I am seeing that it is possible that both parties may even go to the Court of Appeal. The Akpabio that I know, who was my governor for 8 years, is not someone that has tolerance for dissent. In the world where Senator Godswill Akpabio exists, dissent is not tolerated. So I know that this has become personal, this has become egoistic, this has become a clash of personalities. It is no longer even about the institution of the Senate. It is now about ego. Be aware that Natasha has also filed a civil lawsuit against the Senate president. Akpabio has also filed corresponding lawsuits against Natasha. So this has not resolved the problem between the both of them. But I'm sad that the Nigerian Senate is being reduced in this manner, and that the institution of the parliament is being used to pursue personal agenda. So let us hope that this matter will be resolved, because another way to look at it is that it looks like the judge, the learned judge, Honorable Justice Binta Nyako, was trying to give both parties some sort of honorable exit. The court seems to have given both sides an opportunity to work on and claim victory. Because the Senate can say, well, the court has affirmed our disciplinary powers. The court has also asked her to apologize. I expect that if allowed to prevail, the Senate should immediately recall her, and maybe Natasha should attend the apology as ordered by the court, and let people just simply move on.
All right. We now have Todimu Ige. He's also a legal practitioner. Thank you for being here. Remind us again, what powers does the Senate have in the first place to suspend a senator? I mean, we have seen in books and has played out in a few rulings that the Senate does not have the prerogative to suspend a member. Why does this still repeat? Todimu, the question is for you. Okay.
You see that the court has ruled and said that.
All right.
The court has ruled and said that the use of power.
Okay, we apologize. The networks seem not to be nice to us tonight, so we'll stay with Inibehe for now. I want you to talk to us about how the Senate, I mean, from all you've seen, the optics, you said that the Senate president is not one to tolerate a dissent, but would they accept and follow the court's order to reinstate Senator Natasha Akpoti?
Well, I expect them to comply with the order of the court, because really, what is the point at the end of the day? What is the objective? To say that Natasha should not represent her constituent for 6 months, for me, it's just simply ridiculous. It is ridiculous. There is no jurisprudence that should permit that. There is no civilized jurisprudence that should allow Parliament to deprive Nigerians from a constituency from having representation for 6 months. And I've told you that even in cases decided before now, the court have been clear on that matter. If you look at, as the General Judge noted, the standing orders of the Senate and the Legislative Powers and Privileges Act, the court cited Section 14 of that act and chapter 8 of the standing orders of the Senate to say that the duration of the suspension is not specifically prescribed, and that in any event, 6 months is clearly excessive. It contravenes the Constitution, because under the Constitution, the National Assembly, both houses have to sit for a minimum of 180 days per year, 181 days per year. So if you are now saying you are suspending someone for 6 months, you are simply saying that you are denying that constituency the constitutional right to representation. And I have said that this was a personal grievance elevated to a parliamentary dispute. The issue between Senator Natasha and Akpabio was basically about her complaint against the person of Senator Godswill Akpabio. But because Akpabio is also the Senate president, he is able to use the instrumentality and the paraphernalia of his office to basically prosecute his case in this matter. So this has to be resolved quickly. Senator Natasha should be allowed to resume a parliamentary function by Monday.
Okay, there's just this question I really would want clarity, not to put you on the spot, but the judge in the ruling faulted provisions of Chapter 8 of the Senate Standing Rules, as well as Section 14 of the Legislative House's Powers and Privileges Act, declaring both to be overreaching. What does this rule say? I don't know if you can, if you have that at the tip of your hands, really.
Well, it basically gives the Senate disciplinary powers over its members. There is no dispute about the fact that parliamentarians can misbehave. I mean, in all jurisdictions, in the U.S., for example, they have what they call censure, where if a parliamentarian does something that is unparliamentary, they can bring a motion before the Congress, before the House of Reps or the United States Senate, to censure that person, to basically reprimand that member. So all parliaments across the globe, whether presidential system or parliamentary system, Parliament always has certain powers over its members in terms of discipline. The problem with those provisions is that, and this case, and even the ones before it, is that they are now invoking the extreme measure of suspension, and not only to suspend the member, but to suspend the member for almost an indefinite period, or for a period that is clearly excessive and unreasonable, as we have seen in the case of Natasha. To say that you want to deprive her of oath of office, right, of a certificate of return, and the vote cast for her for 6 months, is unacceptable. So those provisions conflict with the provisions of the Constitution that gives Nigerians, and particularly Nigerians from Kogi State who voted for Senator Natasha, the right to representation, the right to vote and be voted for. Because if you have the right to vote and your vote is tallied and declared, and a person is declared on account of that vote, you are saying that you are sending someone to represent you.
Okay. Thank you so much for speaking with us. We do appreciate your time with us, as always, especially tonight. Thanks again.
Thank you for having me. My pleasure speaking with you.